Hi, friends. There's a sleeping giant of a case pending in the United States Supreme Court called Fisher versus the United States, which actually has the potential to disrupt two of the four counts against Donald Trump relating to the January 6th insurrection that are now pending against him in federal court in Washington and set to go to trial on March 4th. This case doesn't technically have anything to do with Donald Trump, but it does have to do with the statute under which Jack Smith charged Donald Trump for two of the four counts. In this case, the defendant, who is also charged under the same statute, argues that the law that dates back to the Enron accounting scandals and document shredding by accounting firms is all about documents and business records, and you can't use it for January 6th. Around 300 people have already either pled guilty or been convicted under the SOX Act relating to their activities on January 6th. But the Supreme Court nonetheless decided to take this case. And essentially the argument is January 6th wasn't about documents, so you have to throw out those counts. Now, Donald Trump's case involves fake slates of electors. That's a document. So even if the Fisher case holds that the SOX Act can't be used around January 6th, Jack Smith has a good argument that Donald Trump's an exception because even though he didn't storm the Capitol, he did engage in falsifying documents. Best case scenario, it doesn't affect the January 6th prosecution of Donald Trump at all. Worst case, two of the four counts go out the window. Or Donald Trump, if it goes to trial prior to the Supreme Court's decision, has a basis to appeal it and argue that the conviction should be thrown out. At a minimum, it really could delay the March 4th prosecution a few months, even potentially to November. And that ultimately, friends, is Donald Trump's best defense in all of these criminal cases. Delay, 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 because on the law and the facts, it's really a loser for him.